Yeah. We'll get going. Good afternoon, everyone. Thanks for joining this Goal 5 Cultural Areas webinar specifically for local governments. I'm Kirsten Green. I'm the Deputy Director and I serve as the Tribal Liaison here at the Department of Land Conservation and Development. The Tribal Liaison part is at the Director's Delegation. And it's really a pleasure to be here. I want to sincerely thank the League of Oregon Cities and the Association of Oregon Counties, Brandon and Alexandra, for helping us get the word out and co-host this local government series. So we'll cover those dates coming up, but this is the first of 4 events. The webinars are the bookends, and in between we'll have 2 open houses that we intend to just be more informal for discussion and Q&A. And we'll recap those dates in a bit. Let's see. So we want to just remind folks we're working as a Department of Land Conservation and Development. We work under the Land Conservation and Development Commission's charge. We'll go over that in a moment. We are again recording this. It is live streamed on YouTube if things are working correctly. And the purpose is to provide information about these draft rules, to receive sort of informal feedback to support implementation, and also to point people to the formal consultation and public comment period that's open now. We look forward to receiving your comments in writing through October 31st. So a good 2 months here of continued consultation and public comment period. And then looking forward to packaging all that comment up for the commission for their consideration and possible adoption on December 4th and 5th this year. I want to just give a few shout outs here and then turn it over to Commissioner Thompson for a formal welcome. But I want to just thank the Rulemaking Advisory Committee members who have served for sometimes more than 1 year now on this process. And also our Commissioner, Leanne Thompson, Hudson County Commissioner, who has been with us since the outset. We named this slide just the core team because there's really many others who have been involved and support and help shape these rules. But also just appreciate our director, Brenda Bateman, who has authorized this rulemaking, and then also, of course, the commission and Governor Kochek's Tribal Affairs Director, Shana Redford, who may just be having some trouble getting into the meeting. So I'm gonna make sure.
I'm on the meeting. I don't know.
You are.
You mean, yeah. I mean, there's probably a lot of faces on
there
the so I'm here.
There she is. Perfect timing. Director, would you like to just introduce yourself and say a few words? Can we promote? Are you a panelist?
Sure. Hi everyone. Hi commissioners and staff, and also the Rulemaking Advisory Committee and all the folks online today. Amazing turnout. I don't know if it's amazing turnout. It looks like a lot of folks online right now who are interested in learning about how to work in partnership with, of course, the state and the tribes, and the understanding the importance of that. And so I just wanted to thank the commission and the department for initiating the rulemaking and pulling folks together and creating this opportunity to educate and inform and answer any questions. I serve as the Governor's Tribal Affairs Director. It's an unprecedented position. It's brand new. Been here for almost 2 years in November, and it's been really a huge honor to be here and to work with lots of folks, and also with the tribe. So a big focus of my work is to help facilitate gov-to-gov relationships and partnerships, and also advise the governor on policy issues. And so one of the pieces that we are focused on right now is tribal consultation and coordination and communication. And so the governor is, it's paramount to her to have strong gov-to-gov relationships. And so, you know, I just want to say thank you. I don't want to take up too much time. I know there's a lot to cover here today, but just wanted to say thanks to the team. And I can stay on for a little bit longer if folks obviously have any questions, but you probably don't. So anyway, just thank you all for being here. Looking forward to implementing and yeah, just growing these partnerships together towards implementation.
Thank you.
Yep.
Thanks for coming over and taking the time. And for folks who are going to the Oregon chapter of the American Planning Association conference in October, Director Redford is going to be leading a panel on all the context and strategies for protection of cultural and archaeological resources on Thursday, the 16th at 11 a.m. So if you're going to Bend, please catch me there as well, Director. Thank you. In the room here today, we have Gordon Howard and Jeff Miller. Gordon, thanks. Community Services. I think manager is your proper title. Sorry about that. Yep. And then we also have John on the phone, John Dennis, Community Services Specialist. But just want to appreciate, you'll hear from Amanda, but the sort of policy team, Alexis and Alyssa, as well as the rule writing team, Kasseri and Matthew. So it does take a village definitely to pull a rulemaking effort off. Here's the Superstar team, the 2025 Rulemaking Advisory Committee members, representatives of 8 of the 9 tribes, and we've been in touch with Burns Paiute as well, who wasn't able to kind of capacitate serving on this committee. But really grateful for everyone's service, local governments, community-based and community-serving organizations, and obviously local governments around the state. John Polly, the state's archaeologist, and also Dr. Alyssa Bullion, who is the physical anthropologist of the Legislative Commission on Indian Services. So really a great rulemaking advisory committee. So just thank you to everybody. So with that, could I turn to Commissioner Leanne Thompson for sort of a formal opening remarks from the commission?
Thank you, Deputy Director Green. It's interesting you say I'll give formal presentation. For those of you who know me and whether or not you love me, informal, exuberant, grounded, I hope, in wisdom, and visionary as we go forward together, looking to do something that is, as far as I can tell, something that hasn't been done before. We're talking about honoring 2 disparate cultures and practices and mindsets. It's a challenging task. And as I've listened to everyone deliberate and toss back and forth the ideas and the positions, it's fascinating to me because this hasn't been done. How do we do it? We're coming together. We make progress every time. I like the flexibility that we're having with a variety of venues and varying degrees of formality. But as we bring our whole hearts, as we bring every bit of intelligence and wisdom that we have to be together today and going forward, I'm grateful to be part of this with you. Thank you.
Commissioner, thank you so very, very much. The rest of our program, we have 2 hours together. Not everyone will be able to probably spend that much time with us, but in the beginning here, Amanda and I will give just a little bit of background, then we'll open up, we'll hear from Jill on the Coos County experience, and then we'll open it up for just discussion. I'll move right along. And just harkening back to, Amanda and I put this in this morning, we're harkening back to 2023, the commission initiated this rulemaking in November in Medford, was that meeting in Medford. We had these guiding principles, which was to improve awareness and reduce impact to culturally important areas around the state, to respect permitting timelines in Oregon law. These things don't necessarily go together all the time, so it's been a challenging path to weave. And then, of course, support Governor Kotek's housing production objectives. So mindful keeping an all-in mindset here. These slides will help put these on our website after the meeting. But you can see here the charge from 2024, and then building on the commission did pass a full set of rules, most of the rules in 2024 in December, just last December. And then in 2025 asked us to take another look at who can directly bring an application to include a culturally significant landscape feature on a local comprehensive plan. And that question was, would it be Oregon tribes and other culturally identified groups? And the RAC has come back and recommended limiting that department, and the RAC have come back to limiting that to only governments in Oregon, which would include tribes. So other culturally identified groups, unrecognized tribes, terminated tribes, tribes from other states, other community-based culturally specific organization can certainly still appeal to a local government to bring that kind of a comprehensive plan update. So there's still a pathway. And then the second element of the charge was to reconsider how these amendments would be brought and considered at local governments. We've always kind of in our heart felt that these are legislative matters of policy, but under Supreme Court case law, we really decided we needed to just leave that silent, because there are some conditions in which an application for it, for example, a specific property would be considered quasi judicial. So the rules stay silent on that part. And then through working with the expert staff at Metro, been working to better define the rules for Metro urban growth boundary expansions. That is a unique local government, of course, in Oregon that doesn't manage comp plans for its member cities and counties directly. So we wanted to sort that out. I wanted to just, do a little bit of the why here. So before I get to that, here's just some little bit of run up on the recent rulemaking. There was additional rulemaking in Goal 5 back in the 90s, but in this recent effort, this was brought to us by representatives of federally recognized tribes in Oregon, brought to the commission, brought to the department in 2021, with the Legislative Commission on Indian Services interim director, Danny Santos at the time. The commission was very interested in addressing this. We conducted a survey of local governments at that time. Thank you for those on the call who answered that back then. That was very formative to us, letting us know a good sample of what local governments were doing already and where folks really didn't have very much information. So we realized there's a pretty significant information gap around tribes and how better to work with them and to serve them and their interests on the lands that we work in. So we formed a tribal work group to help Amanda, me, and Gordon get our heads around, the department get our heads around what would this look like, what would the purpose be, what are cultural areas and resources, and to give a lot of appreciation to those members from the 9 recognized tribes that helped us advise us during that year. And then we officially kicked off rulemaking with the commission's charge in 2023. Went out and publicly recruited Rulemaking Advisory Committee, and then worked on developing the rules with them. The commission adopted those base rules last December. Much of what you see in the rules today are from that adoption. We just hadn't filed them to make them effective because we knew that there was an interest in looking at a few other issues. So what you see in the rules, and we'll put those in the chat in just a moment, if you haven't found them already online, those they show all as new, but a good body of that was already adopted by the commission last December. So then the refinements this year, which I spoke to just a moment ago. So a little bit more background and context. Indigenous people have been here in Oregon, tribes, clans, bands, families, communities since time immemorial, appreciating and caretaking this space, living often with it for thousands and thousands of years, making those of European and other associated descent pretty new here. So I think when Commissioner Thompson speaks about these two cultures, that's what I hear speaking to, is those of us that are relatively new and those of us whose families have been here for many, many thousands of years. So appreciating those two cultural contexts and learning how to do better together. Senate Bill 100 was silent on tribes. It was that and the original comprehensive plans were developed during an era of termination of tribes. In 1954, Congress passed the Western Oregon Indian Termination Act and terminated 61 tribes in Oregon. The year before was the Klamath Termination Act in 1953. These are pretty traumatic events. It's just by their name alone, you can tell. And during the time that local governments were completing comprehensive plans and doing the first inventories, 5 of the 9 tribes had been terminated, were fighting back for recognition. And the Burns Paiute tribe was recognized by the federal government in the 1960s. So sort of had a disconnect there of developing local comprehensive plan with tribes fighting for institutional recognition. So just ask everyone to hold that knowledge as they consider these rules and how we can do better. We did not have Division 23 rules implementing Goal 5 for many years, since 1996. So that's another story. Folks are interested in that, we can talk about that, but 30 years later, we're looking to kind of mend that gap and provide guidance to cities and counties on how better to engage, notify tribes and engage with tribes in local land use planning processes and permitting processes. So at this juncture, this is where I turn it over to Amanda, and we'll put some resources in the chat, Matthew, so if you'd help me with that. You will have to cut and paste them into your browsers, but we'll put the rule from our website in the chat. Also a flyer that Planning Director Jill Rolfe of Coos County helped us develop, and we'll put that resource in the chat as well. We'll put a link to the Legislative Commission on Indian Services inadvertent discovery guidance and resources on their website in there. Also the form to provide comments on the rules, and that's open until October 31st. So feel free to comment early and often, but it will close at October 31st at 11:55 p.m. And then also just the general rulemaking webpage where all these resources are listed. I don't see any hands up. Just maybe pause for a moment if there's any questions at this time. Being none, we'll turn to the real meat of it, the heart of it. Amanda Penton, please.
Good afternoon, everyone. Thanks for taking the time to join this webinar today. I'm going to do a pretty high-level overview of the rule. I'll try to be covering all the kind of major points, and my presentation here is going to follow the outline of a flyer, 2-pager, that I believe Kirsten just put a link to in the chat, and is also available on the website, on our rulemaking website. So what we're talking about today is a new rule that will live in our Oregon Administrative Rule Chapter 660, so the set of rules that our DLCD's set of rules, and Division 23, which is the set of rules that speak to how local governments address statewide planning goal 5. And cultural areas has been listed as a goal 5 resource category since goal 5 was first adopted or identified. But since the new rules, or the new rules, it's still called Division 23, sometimes new rules, although they were adopted in 1996, since they were adopted, cultural areas were not transferred over from the old set of rules. So this rule will now create a rule for cultural areas within our Division 23 and provide more direction on what it means to identify and protect cultural areas. So the main objective of this rule is to bring more awareness of archaeological sites and culturally important landscapes into discussions about land use at the local government level. And the reason why this is important to do is that these cultural areas are kind of the physical component of cultural heritage. And once those physical components of important cultural heritage are lost, they're lost forever. So hopefully, through implementation of this rule, partnerships between local governments and tribes will be strengthened, and that will result in improved identification of tribal cultural heritage and other culturally important features. It's not just about tribes here, but we are kind of more focused on tribes. Respect for these resources and recommendations for how these resources can be protected. So the reason I want to raise the issue of group of cultural areas that are important to groups beyond tribes is that the definition of cultural areas in this rule includes archaeological sites, and archaeological sites are kind of origin agnostic, right? So it's sites that are over, for the state definition, over 75 years old, and significant sites, not necessarily Goal 5 significant, but by state statute that implements archaeological rules, sites that really help to tell a story about what came here before us. So archaeology is important to tribes. It's important to other non-tribal people in Oregon, and landscape features in the definition for cultural areas include landscape features that are important to other culturally identified groups. Another point I want to make here is that as I go through what the rule requires, a lot of it focuses on notice requirements in order to create more conversation between local governments and tribes. What the rule presents is a generic approach to building that increased communication, but it also encourages and provides an avenue for local governments and tribes to develop custom strategies for communication that can replace the generic notice requirements that are in the rule. Next slide, please. So the rule requires several things of local governments. So the list here, we have local government permit applications for development that will result in ground disturbance activity will need to include information about our state archaeological permit laws, and what is needed to be done in the case of inadvertent discovery of an archaeological site. And that strategy for supporting both implementation of our state laws about archaeology and also supporting protection of important sites is already used by several jurisdictions around the state. So this rule would say, let's take what other jurisdictions are doing and have all jurisdictions require that information on their permit applications. So then we get into the notice requirements that are in the rule. So the rule would require that tribes be notified of certain land use applications within 7 days of receiving that application, and then follow up at time of public notice. So essentially, the tribes will be included as interested parties for public notice on an application. So when this statement here talks about certain land use applications, the rule explains what that means in section 5C, and the kind of the universe of applications, in addition to the ones that are yeah, this is where, so we've got two, we've got ground disturbing activities, and that well, any notice is only required for applications that would be going through a public notice process, right? So we're fitting this communication within a public notice and public review process that already exists. We're not trying to tell local governments they need to create a new public review process. They just fit the tribes into existing public review processes. And so section 5C of the rule speaks to approach to providing notices that is intended to receive information about potential impacts to archaeological sites. And then section 8A of the rule is intended to request receive information about landscape features that might be in important cultural landscape features to tribes that maybe some adjustment to development could result in avoiding impacts of those features. So notices go out in some cases, responses will come back. And if its response comes back to a notice, then the local government must take that information and include it in the record of the application, unless it is information about an archaeological site that is sensitive information and not subject to public disclosure laws, and by best practice is kind of reserved for as a need to know on an need to know basis, because yeah, it's best not to share widely information on where archaeological sites are known to exist. And then this information, if it comes back from the tribes, would be used to develop recommended mitigation approaches. So basically, mitigation here means ways to avoid impacts to a site. Those are only recommended by the local government. This is not a way to, the rule is not requiring conditions of approval be put on an application. Again, it's really about communication, sharing information, and trying to get people to be more aware and respectful of these important resources, and do what can be done to avoid impacts. There's one situation where the rule does say that a local government must include a condition, and that is only when an Oregon archaeological permit is required by state law. So essentially, if the local government gets information that development is proposed in a recorded archaeological site, then that already is required to get a permit by state law. So the local government would just kind of wrap that into their approval and say, yes, get that, you know, show you have that. So you've applied for the permit as part of a condition of approval for the development. And then I want to take time to mention here something that's not on the slide, but the rule also has a requirement that local governments have a process in place to receive and process applications that come in from an Oregon-based government to add a landscape feature of cultural significance to a local inventory. And I either in my notes I lost a slide, or we'll find out as we go through here, because I thought we talked about it more before, but I will come back to that point later if we don't have it adequately covered here. All right, so back to who gets notice. Federally recognized tribes in Oregon who wish to receive notice. The way the rule describes it is tribes with an ancestral connection to land within a local jurisdiction, but that's all. The tribes are the people who identify, you know, where their ancestral connection is. So basically, if a tribe asks to receive notice, then they will be on a list of tribes that a local government will need to notice. And each jurisdiction, each city and county will be provided a list of tribes to send notice. That list will be provided by the Legislative Commission on Indian Services. What's in the notice, you know, pretty obvious here. Enough detail for a tribe to know where the development is going to happen or proposed to happen, and understand enough of its elements so they can kind of judge what the potential impacts might be to an important site. And I want to say that the notice is sent out both, you know, the 7 days after an application is received, and then notice is sent out as just part of the regular public notice procedure. That advance notice, the 7 days, within 7 days of a local government receiving an application, is really just to give tribes more time to review the information and try to come back with relevant input to the review process. And I made the point about the receiving and processing applications for cultural landscape features. I do want to say that I think I used the term, these applications can be submitted by Oregon governments, and the rule describes Oregon governments as state, local, and tribal governments within Oregon, and local governments includes metro regional government. And so now I think we're going to I'm going to pause for questions here.
Right. Thank you, Amanda. Yeah, that was a lot. Teresa did have a good question about, as you were discussing the comments back from tribes and any condition of approval. Teresa was wondering how to make that clear and objective. Teresa, do you mind coming on, and do you want to come on and give voice to your question? Jess is, I think, doing some magic there to allow you to speak if you'd like.
Sure. Can you hear me?
Yeah, perfect.
Great.
Thanks.
Yeah, I just, as Amanda knows, we recently went through an update of our Goal 5 process, and it's hard to make some of these things clear and objective where you don't know what exactly you will find there. It's particular to the site, and maybe the mitigation would be particular to the site. So it's just, and if it's in an area where it'll be housing development, then it needs to be clear and objective. So you know, like what your standard is, you need to lay that out. So it's just something to be aware of, that it could be a potential problem, as I'm assuming we'll need to develop our regulations to put this process into them, and we'll need to somehow, we can't just say mitigation, or can we?
So Teresa, because the rule just says that local governments recommend mitigation, or let's call it avoidance. So recommend measures that could reduce or avoid impacts to, whether it be an archaeological site. So let's say an archaeological site, this existing state law does not really kick in until you're in there mucking around with an archaeological site. Hopefully people don't get to that point if they don't have to. So the best way to not get to that point is to avoid. And so the local government, through information that they receive on the potential location of those sites, can recommend how to, I don't know, maybe it's a site design element to try to avoid digging in an area that would disturb an archaeological site. But it's a recommendation. And because it's a recommendation, it doesn't have to be clear and objective. It's because it's not a requirement.
If
Gordon, yeah.
if I could add to that, thank you for the rest of your question, Teresa. Nice to hear from you again.
Yeah.
One of the answer to your questions is that Washington County and other local governments aren't required to amend their codes with any substantive provisions as required to this as a requirement of this. What this is an informational item, and it gives tribal governments the ability to provide information. And then at that point, it's up to the county and the applicant. And, you know, if you don't have any specific approval criteria at that point, really, or code provisions to implement it, at that point, really, it's a matter of negotiating with the applicant. This is really more of an informational thing for the tribes to get their input in. And it may be that, you know, if the state were ever to look at these rules again to make more substantive requirements of local governments to amend their codes, then we would get into a lot of questions about things like clear and objective standards. But that's not at this point. If a tribal government provides a provision, you know, a comment to Washington County on a housing application, and the only way to implement it is not a clear and objective standard, unless the applicant agrees to it, really the county has no option to apply that in that circumstance. So this is really more of an informational thing than a substantive requirement to implement the tribe's recommendations.
Teresa, thank you for raising that. We might pop this into a running list of frequently asked questions, just to sort of mark in times. If you're wondering, others are probably wondering, you know, would be wondering too, how to how to avoid and adhere to clear and objective standards requirements. So thank you. We'll keep
Yeah.
thinking about that as well.
Yeah, well, I mean, it was good to hear that the expectation is not that we amend our regulations and put all of this in there, that it's just adding not just, but it is adding the tribes to um the groups of people that we notify of applications, and then we get recommendations from them. It could be a bit frustrating for the tribes to not have something more, I guess.
Right. This is definitely, I would say, you know, a step.
Yeah.
But knowing also, you know, the demands on local governments right now with lots of work, you know, locally generated, also state generated, and not having large sums of money to be able to appropriate to local governments to update codes. We try to leave a pragmatic balance. But thank you again for the question, Gordon. Thanks, Amanda and Gordon. Thanks for your response. Sheila, you had your hand came up during Teresa's question. Did you have anything to add?
I just had a question for Teresa. So Amanda said that this really is only triggered when you're going through a public hearing process or a noticeable decision. So if you're doing clear and objective standards under your code, that's not a noticeable decision, is it?
Well, if I could, I'm sorry, go ahead.
No, you go, Gordon. You're the attorney.
Okay. Well, yeah, Amanda and I just had interestingly had a discussion of this a few minutes before the meeting. What if the county or the city or any local government makes something basically a quasi judicial application, which technically is not required to be one by state law. And the way the rule is written, anything the county chooses to make a quasi judicial application is subject to this rule. So if Washington County or any other jurisdiction, for instance, takes in, for example, grading permits and makes them quasi judicial decisions, even though they don't have to be, because they've done that, then the county does have to provide the tribes notice. It's based upon it being a quasi judicial application. I think we use a different term in the rule, but that's basically what it is.
Right. And that was my point. I didn't, when we do clear and objective standards, we don't do it as a quasi judicial permit. They're just permitted outright. So I was just curious if there was another county that did it differently.
I think there are a lot of jurisdictions around the state that still do housing applications, even involving clear and objective standards as quasi judicial applications.
Thanks, Jill. Thanks, Teresa. We can loop back to this as we need, but Matt also put a question in the chat. Matt, do you want to put voice to that as well? It's pretty straightforward, but if you'd like to come on, it'd be good to hear from you. Be unmuted, unmutable. I can also.
Oh, there goes.
There you go.
Yeah.
Awesome.
Just wondering if that meant we have to notify the tribes when the applications come in. Did that mean 7 days within receiving the application or deeming them complete? Because sometimes a lot of applications never reach completion and end up just fading away.
That's right. It's the receipt, Matt. So Amanda will correct me, but I do believe it's the receipt.
That's correct. And we had lots of conversation around this, and the reason to this is like a new or additional notice requirement, and the reason for it is that it will provide additional time for tribes to respond or be able to read and possibly respond to these notices. It's, we kind of thought at first that it gave 30 days potentially for conversations to happen before the application was deemed complete, and maybe some changes could happen during that time. But we realized that the 30-day requirement to decide whether an application is complete or not, that's the maximum. I mean, sometimes you could decide an application's complete the next day or when it comes in. So it's not necessarily we don't know all the time if it's going to provide extra time for tribes to review and respond, but in some many situations, it will provide another, 3 or so weeks for a tribe to see see the information and respond. And so that's why we have the notice at the time that it's received, and then the when actually the public notice on the application goes out. Now, the rule just says that, the information is like as it's provided in the application. If you don't have hardly any information, then you can't give any information. But if hopefully any application will at least have an address and some rudimentary explanation of what is being proposed.
Great. Okay, thank you. Hopefully, Matt, hopefully that clarifies. Thank you. And Amanda, I believe we were about to head into just another section of the rule, which is about urban growth boundary amendments.
So when I just, fun fact, I guess, our printer is being really funky. So when I tried to print out the slides to make my notes on, I wasn't able to do that. So I did it a different way. And in doing it the different way, I lost this slide, which is why I got ahead of myself before. So I'm glad the slide is here because I thought it was here. So here we go. So local governments under this rule would also be required to accept and process applications from an Oregon-based government. The rule defines Oregon-based government. I said that earlier as a state, local, or tribal entity in Oregon. So for tribes, we're still talking about federally recognized tribes in Oregon. And so these applications can come in and say, hey, this is an important cultural landscape feature. We think it's significant for these reasons, and we would like it to be recognized by the local government and added to the Goal 5 inventory and the comprehensive plan. So an application like that would come in, the local government could require a fee for it, like other applications, and then that assessment of significance would happen through a public process. And if for any site that is deemed to be significant, then the rest of the Goal 5 process would be followed. And that includes conducting an ESEE analysis, or an analysis of the economic, social, environmental, energy consequences of a decision to allow, limit, or prohibit development that would conflict with the identified significant resource. And then from that analysis comes a decision by the local government, or a creation of a local program to ideally protect that significant site in some fashion. The Goal 5 rules for this part of the Goal 5 process do allow a local jurisdiction to come to a decision that these other factors are, let's say economic factors are so important that they outweigh protecting a culturally significant landscape feature. Same thing can happen for a significant wetland, but the Goal 5 and the Goal 5 rules are in place to protect resources. So a decision to not protect a significant resource is more difficult to get to in the local findings, but it is a possibility. And so then the outcome would be a local program that would protect in some fashion the significant resource site. And here we are just talking about, I guess I've said this, but it's the landscape features of cultural significance. Archaeological sites are protected by the existing laws that exist for protecting archaeological sites that are not within DLCD's purview, but are within Department of Parks and Recreation and Oregon's Heritage Program purview. So, so another section of the rule talks about what happens when there is a proposed UGB amendment. And this is at the time of UGB amendment when it's after the alternatives analysis to decide where the UGB will be amended, but kind of just before that amendment is noticed and for a local plan amendment. Then before that notice goes out for that local plan amendment, tribes must be notified, 35 days for cities and counties, and 45 days for metro. So prior to posting the amendment, the notice for UGB amendment. And then this rule basically incorporates something that already exists in another of our Goal 5 Division 23 rules, which is that whenever a Goal 5 resource site is identified, if there's information of the existence of a Goal 5 resource site within the record of a UGB amendment, that requires the Goal 5 process to be initiated and completed. And I want to make a distinction here is that when I'm talking about a Goal 5 resource site in this context, I'm not saying it has to be known to be significant yet. Like, so for wetlands, we know there's wetlands there. So then that means the city has to go through the Goal 5 rule pertaining to wetlands and figure out which ones are significant and then ultimately locally protect the significant wetlands. So same thing for these cultural areas. If information on a cultural area is in the UGB amendment, then you go through the what's required in the rule for completing Goal 5 process. It really only makes a difference for landscape features because the protections and the process for archaeological sites are just kind of, it's just about notice and following existing laws that are outside of DLCD's purview. So this issue about UGB amendments is really specific to landscape features that are potentially significant landscape features.
Amanda, do you mind if I chime in here?
Oh, please do. And yeah.
No, it was great. Nothing countered anything you just said. I just want to mention this one is again where we had heard from tribes that they would like to be noticed at the time of UGB amendment. They're aware, of course, that with need for housing, there's expedited UGB amendments going on. So this is again at tribal representatives' request. Same protocol. Tribes would let LCIS know. We'll be helping with that survey, but tribes will let LCIS know in which parts of the state they would like notice. There's also the Oregon Housing Needs Analysis rules that are under development. So in consultation on that process, we found that tribal representatives and leadership are interested in being notified at the study area phase, where there could be probably more productive avoidance strategies to happen if and as appropriate. So when those ONA rules come out, the Oregon Housing Needs Analysis rules come out for community review on October 1st. You might see that in there, but just wanted to acknowledge that this is pretty late in the process at the time of UGB amendment, and we're sort of working to encourage collaboration and coordination earlier in the process as well. Amanda, thank you. Shall I go on? Shall I move ahead?
Yes, I saw that Tamara asked a question about Oregon-based governments, which I think I answered, but I'm going to stick in the chat the definition we have here.
Sure. Yeah, that could include SHPO. Tamara, it could include Oregon Department of Fish and Wildlife, as well as Oregon tribes. Yeah, thank you. It'd be state agencies as well as tribes. Theoretically, other local governments. Okay, so this is a pretty significant turn from the rules, the preparing for implementation. So given that the commission passed a base set of rules in December 2024, I would hope and expect that they would continue to pass these rules as modified or not, but meanwhile, we're preparing for implementation. So Amanda, I don't know if you are ready to pick up here. If you are, please go ahead.
Yes, and just make sure there aren't any other questions on the last slide.
On the UGB arena. I'm not seeing any, Amanda.
Okay.
Thank you.
So last year, when LCDC adopted the first iteration of this new rule, there was a decision to postpone implementation. And that we were, what was it for basically a full year, right?
It was 6 months. It would have been, the rules would have been effective in June. They would have been effective June 30th, 2025. So it's for 6 months at that time.
Okay, I thought it was a year. So we don't know. We think we're gonna also be recommending postponing implementation of the rule, and would really would appreciate input from local governments on that point and the timeline for preparing for implementation. So the list of tasks that we are flagging that need to be done. So on the DLCD side here, we will provide templates for language to add to application forms describing what to do in case of inadvertent discovery, and the requirement for state archaeological permits for alteration of an archaeological site. We will provide model language for notice procedures. And we will also work with LCIS if they need our assistance in communicating with tribes, and to generate those lists that we spoke of, where each city and county will receive a list of tribes that the way the rule describes it is having an ancestral connection to the land within that jurisdiction. And it's the tribe that basically says, what that is, and where they want to receive notice, from whom they would like to receive notices. And then we would like to produce a guidance on local government and tribal communication and coordination. How to approach that, when I said earlier about kind of customizing communication between local governments and tribes, this guidance would help with that. And if a local government and tribe or tribes decided to reach an agreement for how they wanted to communicate on these local land use decisions, then that agreement or those agreements with one or more tribes would supersede the requirements that are in the rules for providing notice on all applications that result in ground disturbance, or all that that are required a public process, or in rural areas all applications that go through a public review process. So on the local government side, we know we will have to modify those application forms. You will need to get yourselves set up for how you follow your own procedures for providing notice to tribes, and how responses are integrated into the permit records. And also prepare for receiving these applications to recognize a culturally significant landscape feature. What we have learned is that there are some jurisdictions out there that already have a ability to receive applications for comprehensive plan amendments, and they have a fee structure for those kind of plan amendments, but not all jurisdictions have. So jurisdictions that do not already have that avenue for receiving applications for plan amendments would need to create one for to satisfy the requirement of this rule. So Kristen, did you want people to kind of chime in now with thoughts on time that would be needed to prepare, or do you want that to be something that people think about sending in public comment, or either formally or informally?
Well, if it's okay, let's hear from Dylan then. In discussion, I'd love to hear from folks if they have a sense of how long it would take them to kind of get ready. This is, it's obviously been a long time coming for tribes. So there's that pressure on that side. Folks have been eagerly awaiting. We had 6 months in there. We have heard that wouldn't be sufficient. If we make it longer, it doesn't mean that folks couldn't comply earlier. So we are looking for guidance on that, but first, if it's okay, let's hear from, Coos County Planning Director Jill Rall. Jill. And your experience.
Well, thank you for having me today. I'm Jill Rolfe, Coos County Community Development Director. I serve still as Planning Director as well. Coos County is a little bit unique. We have had a process to provide notice to our local tribes since 1986. So before the rules even changed. And we actually have two different processes because Coos County has two different estuary plans, and then they have a plan that covers the rest of the county. So we have one that's just based strictly on goal 5, and then we have one that is based on goal 17 with the integration of goal 5 mixed with it. So basically, it doesn't matter for us whether it is a noticeable decision or not, or a quasi-judicial notice or not. Any application that proposes any type of ground disturbing that is within our mapped notification areas. So we do have two separate inventory maps. We have notification area maps, which signify if there's a potential for resources to be located. And then we actually have inventoried resources that we do not display publicly. So when the application comes in, there's some things that are required. So you're supposed to provide a plot plan showing where you're going to do some excavation, clearing, and development, including access points. You need to have a map number, and then directions to the property, and then contact information. I think I probably was the one that had a little discussion about whether you should send these notices after an application is actually found to complete or not, because I mean, anybody that's dealt with land use knows that site plans that come from people can look various ways and maybe not provide the information that's most valuable. But basically we give a 30-day time frame. We try to send this notice out within 3 days of receiving the application. And then after the 30 days has passed, if nobody has responded, we assume there's no comment. And that's our agreement with the tribes now. Most of our tribal representatives actually do respond. We have two different tribes that we send to. The Coquel Indian tribe and Confederated Tribes of Coos, Lower Umpqua, and Siuslaw Indians. We send a courtesy notice to the Coquel tribe in certain areas. We send both notices in the Coos Bay Estuary Management Plan and our Coquille River Estuary Management Plan. Only Coquel Indian tribe gets notice of that one. In our estuary plan, there's a few more there's a few more requirements. We have what's called a policy 18, which again, it captures both goal 5 and goal 17 requirements for protection of archaeological sites, as well as historical sites. A lot of time historical sites can be archaeological sites. We actually require a full site plan review in these areas. Oftentimes there's other inventoried resources that we're protecting. So the site plan does require a little bit more detail on what the excavation is, the cuts and fills, whether it's driveways, roads, structural development, or just earth moving development, anything that is categorized as a use or an activity the tribe receives notice of. We do have a conflict policy. So for instance, if the tribe comes back and they're really concerned about areas that need to be avoided, and the applicant hires their own archaeological professional to say, you know, we don't believe that, you know, that this is going to impact, and we can't come to an agreement, we do actually have a public hearing process that you can go through to resolve that issue. And there are certain criteria. Since my time here, I've been here for over 20 years, we've only ever had one conflict hearing. And so, most of the time, people are, they're respectful. They do not want to dig up artifacts, or they are working with the tribe. Our tribal professionals that work with the tribe are really good about saying, if you provide me notice, we can be on site. They will help you in areas. I know that not all tribes have that capabilities, and that was one of my concerns with the expansion of the rule. But I think that, working with the tribes for us has been positive. I can't really think of anything negative. So I don't know if anybody has any questions on what our processes are.
Thank you, looking for any hands. Commissioner Thompson, please.
I think you're on mute.
There. Okay. One conflict in 20 years. Oh my goodness, that's amazing. In any kind of land use. I have a recognized tribe in my geographical area, but I have another group that says it has heritage here too. Do you ever have conflicts between various groups? It isn't two tribes, because one tribe had recognition and then it was taken away, but do you ever have those kinds of differences that you have to resolve?
We have not, though I do know that there was an issue through SHPO where actually remains were dug up in one area. And of course, they notified the state police, and then SHPO moved in and took over. And I do know that there were some conflicting comments of who really had the say in that matter. But I don't recall how SHPO actually work that out.
Thank you, Commissioner. Thanks, Jill. Yeah, there's in that inadvertent discovery link that Matthew put in the chat, there's a lot of resources on Legislative Commission on Indian Services website. This is not taught to us in planning school. So I encourage everybody to kind of dig in there and just sort of acquaint yourselves if you're not familiar already. But there is all the phone numbers to call in the case of inadvertent discovery, and at that point it's sort of like, they take over Legislative Commission on Indian Services, State Historic Preservation Office, and so yeah, it's sort of Jill, it's like super us, isn't it? It's sort of out of our hands at that point.
Yeah, and I was happy to say, I don't know, here, move.
Exactly. Please help. Exactly. Please help. Thank you. Jill, thank you. Any other questions for Jill? It's a pretty incredible example, and your policies have been sort of a model for these rules, certainly, Jill. I was intrigued, as you know, to learn that they've been around since 1986, is that right? And was that the date of your original comp plan acknowledgement? Yeah.
Yes. They've been modified slightly, but not, I mean, in I think it was 2002, we did have an update to our inventory that happened, but the policies themselves have basically been the same. There might have been a little bit of modification here and there, but nothing substantial.
Amazing. That's anyone wants to do the math, but that's a long time now. 40 years now. That's amazing. And the tribes represents the tribes and tribal leadership at the time help the county put that together. I understand.
Yes.
You shared with us. Yeah.
Yes, Don Ivy was instrumental in putting the information in there, and then Bill Brainerd was also from Confederated Tribe, also served on our planning commission and was very vocal about these policies.
Amazing. Yeah. Amazing the difference that just a little intervention can make at the right time. But thank you. Thanks for your just testimony to how it's been working for Coos County and your experience over 20 years. That means a tremendous amount. I don't see any other hands for Jill. Ma'am, thank you. In the next webinar, I think Jill's able to be here at each of the webinars and the open houses, unless you get carried away by other matters. But for now, I think Jill's planning to be with us, even in the informal, kind of more informal open houses. So if folks have questions for Jill, please come back. Jill, thank you.
You're welcome.
I think somewhere I have the PowerPoint again. I just need to find it, and I will then go to the next slide. There we go. Thanks, Jill. So just a little reminder about next steps, and we want to go back to Brandon Reich's question in the chat. But just some housekeeping reminders for comments online. I don't know why I have October 5th in there. Jess, I'm sorry, I'll have to restate the PowerPoint before you post it online. That's incorrect. It's October 31st. It was October 5th, a long time ago. But we've extended it to October 31st. There is a live comment form on DLCD's webpage that we ask folks to use to make their official kind of written comment. And then there's the upcoming events I mentioned. The two open houses will just be drop-in. They won't be live streamed, so a little bit less formal. And then the closing webinar on October 29th, we'll do a little bit more formal again to just share with whoever's interested what we've learned through the comment period and forecast the next steps. I will say that there is a hearing, and Matthew, maybe you could put that information in the chat, but I meant to put on the site, there's a hearing at the Land Conservation Development Commission's meeting in Klamath Falls later this month on September 25th. So please feel free to come on voice and testify directly to the commission if you wish. Perhaps Matthew, if you can figure it out, you can put also in the chat how to sign up for public testimony at that meeting. It is in person in Klamath Falls, but there's certainly online options to testify. All right, so thank you, ma'am. So I think, yeah, let's go to Brandon's question. Amanda, Brandon Reich had a question in the chat. Brandon, do you want to come on and say it directly? We find real human voices refreshing around here. So if you want to, please feel free. You had a question about 8A.
Yeah, hey there. Sorry, this is actually Austin Barnes from
Okay.
Marion County. I guess I'm somehow coming up as Brandon Reich, even though I'm
Sorry about that.
No, that's all good. That's all good. I could have just ran with it, you know. But yeah, my question is, so section 8A in the rule, it talks about for local authorization, subject to quasi-judicial review on rural lands, etc. What do you guys mean as local authorization there?
Approving a permit to a development permit.
Okay, cool. So just any land use decision, basically.
Yes, let me go back. Let me just get there. I'm almost there.
And Gordon, can you think of why we would have used a more opaque term there?
No,
But we might be able to use some more plain language there, Austin. Thank you for pointing that out.
I think we did change the term, but I mean, I think it might have been land use decision, and now it says local authorization, 8A. Yeah.
And is that defined elsewhere? I don't believe I found it defined elsewhere in the rule.
It is not, but we're trying to get at, a decision that a local government is making that allows development to occur, consistent with their comprehensive plan and codes.
Sure. Okay, thank you. I appreciate the explanation.
Yeah, thank you.
Yeah,
Thanks
if you
for
got a
pointing
better
that
way
out.
of saying it, then yeah, let us know.
Yeah, we might just check that out.
Yeah, for some reason we thought it might be something in addition to land use decisions. I don't remember what our thinking was there, but we'll look at that.
Yeah, thanks, Austin.
Didn't that have something to do with the limited land use decision or something that was included in the definition?
Yeah, or expedited land division is the one.
Yeah.
So.
And I'm not sure why we wouldn't put it in definitions. We can look into that. Thanks. So if it's causing question, that it's a clue that we could probably make it a little bit more clear somehow. Thank you. Any others? We don't have to keep folks till 3, but we booked a long time. Thank you so much, Matthew, for putting in the information about the hearing in the chat. Not seeing any other questions.
I've got one more I could do that might be sort of a
Great.
general question.
Yeah.
In these rules, you know, it talks about having some meetings with local tribes and coordinating, depending on what is found in development of a site. Have you guys thought about, or I don't believe it's spoken to in the rule, but if those sorts of coordination meetings and such activities were to extend past a 120-day timeline or a 180-day timeline, is there, do you guys have guidance about that, or has that been thought through, that if these procedures sort of take longer than our timelines, what should local governments do at that point?
Mhm.
Yeah, I think
Awesome,
an
thank
answer,
you.
yeah, an answer to that, Austin, that we have no ability to override a legislative direction to local governments on the timelines. So
Unless, isn't there an unless
Yeah,
the
well-
parties agree?
well, yes, and that includes, you know, the applicant basically agreeing to an extension. If the applicant didn't agree to an extension, you know, this local government would have to wrap things up within the timeline. There's no getting around that statutory requirement.
Okay,
Another
thank you.
good, another good one though for just the kind of frequently asked questions, and the guidance will put alongside start to populate in the coming months. I do appreciate that if the parties agree, because that might be
Well, the landowner agrees, or
landowner.
the applicant agrees.
the applicant, yeah, thanks, Lynn. Good. Yeah, that's one of those guiding principles, is that we kind of have to live within the law here. But I do take refuge in that if the applicant agrees, you know, and as Jill said, in 20 years, they've had really great cooperation, so it's, I would think, possible. Be possible. Jill, have you seen that before? You seen extension of 150 days?
Not in this scenario, but we've done extensions for other reasons. Usually it's the applicant receives some sort of objection and they want more time to make sure that they provide enough information in the record to survive an appeal.
Makes sense, thank you. Thank you, okay. Does anyone have any, now this is the recorded posted version. If you want to share experiences in a more informal setting, come to an open house, but I'd be curious if anyone would like to share any experiences you have, you know, working with tribes in your region. If we had representation here from the Gorge, I know that Dr. Housley Glover would have a lot to share. She wasn't able to make it today. She'll put the other 3 recordings, but there's certainly a lot of experience coming out of Gorge communities on tribal notification that are special. There's sort of have a unique context of there, of course, because the Columbia River Gorge Scenic Area and 4 tribes in 2 states, so unique up there. But anyone have anything they want to share or ask? Just pause. Oh, Matt, please.
I'm sure it's come up a bunch of times on your side, and I'm sure a lot of other people have asked the question, but walk us all through how we tiptoe around takings.
Right.
I'm assuming if a tribe comes to us and says this is significant, but it's on someone else's private property, and they make an application to have that added in the comp plan, and the only mitigation that everyone can think of or arrive to is complete avoidance, how does that not trip over the takings question?
That is, I would say that is an extreme situation, Matt, that would be rare, but you're right that, you're right. Gordon, would you like to touch on that?
So I think that a local government, if it found such a resource significant, Matt, and then doing the conflicting use analysis, conflicting use would be the private use of the land by the property owner, and I think the local government, in determining a protection program, would have to weigh and balance that protection of the significant resource with the conflicting need to not get sued for takings and lose a lot of money. So I think that's the local government will certainly have the ability to the Goal 5 process. The Goal 5 process does not compel a certain outcome, and in that kind of situation, I think a local government would be well within its rights under Goal 5 to limit the protection program to avoid opening itself up to a violation of a constitutional property right.
Okay, that's a great answer, and it's the one I thought you would say. I just wanted to hear you say it.
Yeah. Thank you for asking it, Matt. Some of these are just like the obvious, but that is great. Good. For the real Brandon. Brandon, come on over. Come on in. And you make sure that the real Brandon Wright can speak. There might be a couple. There's a few Kirsten Greens. If we share links, it can come up as the original registrant.
More than one Kirsten Green, that's a scary
I
thought.
know, Gordon Howard, they put him on mute. You do that in real life.
It's actually still me managing the computer. He's bogged down with the Aurora Airport, so these are stuff he sent me.
Oh, gotcha. Okay, great. Okay, let's give a moment and read those. Thank you. I'm glad. Wow, he is definitely multitasking. Thank you, Austin. Okay, so let's see. So Amanda, are you reading here? So it's in 5CA. Look at my rule here.
So 5CA, was he sure I'm in the right spot?
7 days.
Notify.
Yeah.
For negative impacts. Yeah, to a known or suspected archaeological site. So the knowledge about whether a site is known or suspected would come from the tribe.
Let me just read it in case folks are listening. So it's regarding the draft rule language in section 5, protection of significant archaeological sites. Brandon wrote, and it's brought here via Austin, that the language states that notice is given to tribes if the application affects a known or suspected archaeological site. Is this the intent of the language to provide notice only in those circumstances? Let's do that one first, and let's talk about 5E.
Yeah, and I think maybe I can clarify that it's sort of like if we or the property owner don't know or suspect, is no notice given, or is notice sort of given at all times and they let us know if it's known or suspected?
The latter.
Okay, thank you.
Yeah,
Right. Because the wording is different than how it is in your language states that notice is given to tribes if the application affects a known or suspected.
I see
I'm
about
gonna
the potential for, I see.
I'm
Yeah.
gonna paste the actual language in the chat. Because it's
So local
slightly
government shall
different.
send notice. Yeah, local government shall send notice to tribes with an ancestral connection as described in section 10C. And then big A is notify tribes within 7 days of receiving the application, request information about the potential for negative impacts to a known or suspected archaeological site. Right, so that's how the information would be known, because as to quote John Pauley, our state archaeologist, only 20% of Oregon has been surveying for archaeological sites, and the majority of that is on federal land. So so much is not known, honestly. So that's, I guess, the what this does is bring in that conversation around potential. Does that make sense, Austin?
Yes, yeah, I appreciate that.
Okay, let's go to the next one then. And it's 023-02105 sub E. Find that. Section 5 again. Little E.
Um, 5E.
Examples of ground disturbance, okay. So for application requiring permits as defined in state law or limited land use divisions as defined in state law that involve a ground disturbance, a local government shall send notice to tribes with ancestral connection as described. And was there a question in that one? Oh wait, no, sorry, Meta, that was your response. Forgive me, you guys. So Brandon's question or comment was in 5E, The activities listed appear to include nearly all kinds of development, including site prep, dwellings, commercial buildings, and other structures, including installation of plumbing or septic. Is the language intended to be that extensive to include nearly all types of development? I think the answer is yes.
Yeah, this is something else we talked about a lot. And so we've received comments from non-tribal representatives about the number of notices that this requirement could generate. And these non-tribal people being concerned about tribes having capacity to deal with the notices. Tribes on the rack have consistently said, let us handle that problem, so they didn't want limitations on the notice, like, let's say, like number of square footage or of land affected, anything like that. They wanted it to be left this comprehensive, and then they will decide how to work through the notices and flag the ones that are of concern to them.
Okay, thank you for that explanation. One quick follow-up is that, obviously it applies to all land use decisions, as you guys explained before, but for just like a simple building permit, if we've got a residential zoned property that's allowed a house outright, and then we issue them a permit for a dwelling that obviously has grading and digging and all sorts of other activities, would that require notice, or is this expressly for land use decisions?
If land use decisions is the right term, that's what we go back to. It's decisions that require a public notice and a period of time to review the proposal, and basically things that involve discretion on the part of the local jurisdiction. So a simple building permit would not fall into this category.
Okay, awesome. Thank you for the clarification.
And that's in the, in 5, yeah. Yep, good. And then, do you see Teresa's follow-up? Teresa, would you like to come on and ask?
Well, that was just following up on that last question, and I was a little confused if this section talks about installation of plumbing or septic systems or anything like that, because we don't provide notice for building permits or plumbing permits or anything like that. So I'm
right. So I think
unclear.
that wouldn't be, that wouldn't be. It's for the intention is for processes that already provide comment, allow for comment.
Mhm.
In Coos County's case, they provide all, but here in these rules, it's just for those opportunities that provide comment, so that the tribes would be included in that comment process. The way, Teresa, I think that we sleep better at night thinking about this is that with the requirement, and thank you to all the cities and counties in advance, please, for being willing to work with this and to provide notice to applicants, is that when they get their permit to do that expanded, say, sewer, plumbing, then they would receive a reminder about inadvertent discovery. So that upfront, we're just reminding them in the public sector, we're reminding them of what could happen if they come across ancestors or other cultural resources. So that's the front end piece when there's not a public comment opportunity. Does that make sense, Teresa?
It does. Yes,
Yeah.
thank you.
Yeah, thank you. And a survey of local governments back in 2022, and we're really grateful. We had received responses from 45 cities and 12 counties at that time. Folks had said that, a quarter of those that responded self-admitted that their staff is not aware of statutes and rules on archaeological sites. So part of this whole effort is to help our planning community in Oregon and community members and property owners just be more familiar with those resources and hopefully expedite permitting when things can come up earlier. Commissioner Thompson, did you accidentally come off mute, my friend?
I'm still off mute. I'm just thinking, I'm just listening and thinking of, is there any problem I can foresee? And of course, there will be problems, but it seems as though there is a clear path forward that's contemplated, and this raises the level of understanding in a practical way that achieves the goals we intended. That, I mean, that's what I hear today.
Yep, thank you. Thank you. Great, okay, well, with those closing thoughts, maybe we part ways today. We'll get that, the PowerPoint, my note of the close of the hearing date, public comment period, fixed, and we'll post these to the project website. And hope to see everyone at the drop-ins. Those can be kind of, 2 people can show up or more, but we'll be there and we'll stay on the whole time. So it's just, it'll be open for that 2 hours. So thank you, everybody. We hope to see you soon. Take care.
Thank you.
Bye. Thank you.